And away we go. YouTube live presentation number 17. Today is June 22nd. I'm a little disappointed. I only have three left, especially as the humor in the live chat is really ramping up. We got a new one, new contributor out there, Bamalam. Great job. As corny as those jokes are, I laugh every time I read them. So bring them on. Oh, the cover. Probably going to go maybe 30 minutes today, based on the content in my mind. If you've watched any videos before, you know I love the live chat. If you've either got a joke or you've got a question related to estate planning, throw it there in the live chat. So, if it's an estate planning related question, I'm going to answer it to the best of my ability. Even though I may not understand the backstory of your question, I'm going to give it a shot. But one of the reasons I'm doing this live is to give people an opportunity to do the live chat. I'm not a big fan of people asking questions in the comments to my because it's just very time consuming, and I just don't consider that very fun. I much prefer to do it, live as the questions come across on the live chat, or if questions do come across on the comments, I'll mention them on here. So here was one that came across yesterday from Bill, and it has to do with our bank account video, which was yesterday. And so Bill wrote, if the bank account has another signer, in parentheses, son, daughter, doesn't that expose the account to son, daughter's liabilities? And so my best answer to that is I don't think so. I know to me, that's kind of a wives' tale, something that you might hear in the barbershop or the beauty shop or the coffee shop, where if you put your name on, put your child's name on as an authorized signer on your bank account, and they have liabilities, then your kid's creditors are going to take your money that your kid is an authorized signer on. So, couple of issues there. The main issue is, so let's say dad has $100,000 in his bank account and he adds daughter as an authorized signer because he wants daughter to have access to dad's account, particularly if dad dies and daughter's got to pay funeral expenses, legal expenses, other expenses. Dad doesn't want daughter or others to have to wait to go through court proceedings to get access to funds. So, but should dad be worried that if the daughter gets successfully sued, for example, and gets a judgment against her, should the dad worry that the daughter's creditors are going to take dad's money? And my answer is really two parts. First part is really no, because daughter's creditors can seize daughter's assets. With the daughter as an authorized signer on dad's account, that's dad's money. That's not daughter's money. Daughter is an authorized signer on the account, but the daughter doesn't own. She's not an owner. She's not a co-owner. She's not a joint owner. She's an authorized signer, just like Bill said. So daughter's creditors can seize assets that daughter owns. Daughter doesn't own this money. Now, my second part to that question is, quite frankly, if daughter it gets sued, and it's going to take likely years for that lawsuit against daughter to run its course, not to mention whether that plaintiff would be successful against daughter. When daughter gets sued, just to avoid the appearance that daughter may have an ownership interest, you may want to take daughter's assets won't attempt to be seized for years down the road. So that's my answer to Bill's question. And then we got a question here. Paul, can my two daughters be either or trustees? So I think what you're asking me there is, and the short answer is yes. And then the long answer is, individual or couple sets up a trust. They have two daughters. They want the two daughters to be either or trustees when the parent or parents die. So I know here in our state of Louisiana, if you name two people as co-trustees, they have to act together unless the trust instrument provides otherwise. So if you want it to be one of those either or scenarios, and you want to appoint daughter A and daughter B as co-trustees, yes, you'll appoint them as co-trustees, but in that trustee appointment provision of your trust, you would likely add some language that says something like either co-trustee may act individually in transacting as a trustee or co-trustees of this trust. It's not required that they act together to act as a trustee or co-trustee. And I just made up that language off the cuff. But that's the deal when you want to have two trustees and you want to say either one of them can act. It doesn't require that they act jointly. It's just the trust language needs to be specific about that. That's a good question. Hope I answered it. Okay, so on today's issue, this is a big one. My most watched video, and not that I'm any kind of YouTube sensation at all. I'm a small little pea in the YouTube world, but my most watched video out of 400 and something videos was titled "If You Have a Revocable Living Trust, Watch This Now." And I was kind of mad when I made it because I had set up a trust for someone. They died years later. The trust wasn't funded, and you'll know what that means here in a few minutes. And so everybody wants to blame me because the trust wasn't funded. And it ticked me off. And so I made this video. Maybe I was kind of hot when I made it, but it's had over 100,000 views. Again, small potatoes for YouTube. But it's gotten a lot of play out there. So it's one of the biggest issues and one of the biggest obstacles to making a trust work is making sure the trust is properly funded, or failing to fund the trust is a big obstacle. It's a big problem, and we're going to hit that problem and that obstacle head on over the next few minutes. So it's really a common issue because there's many different kinds of trusts, but two in particular that where trust funding is a common problem is one, the kind of typical avoid probate revocable living trust. I'll talk about that one in a second, but then I'll also say it is a typical problem in the kind of nursing home protection irrevocable trust. We see a lot of scenarios where those trusts don't get funded adequately, and assets unnecessarily have to be consumed at the nursing home prior to Medicaid eligibility. I'm going to hit on both of those issues today. My wife and I own and operate 2 LLCs. What do we do to get those transferred into the irrevocable trust we'll be setting up in the near future? Excellent question, Ron. I'm going to get at you in just a minute. It's kind of one of those types of assets that Ron, you're a live chat MVP, and you throw some humor up there on a daily basis. So let's give Ron VIP status. So really how that works is once your trust is formed, and we do this all the same day because we know they have LLCs, we're setting up their trust, and let's say a couple owns the Clark Properties LLC, and they own the RC LLC. And that needs to go in their trust. So when they're signing their trust, we would have also prepared some, I think we call it act of transfer, where we'll talk about how the real estate gets transferred and we get all that set up. But we also do another set of transfers for the LLCs that someone owns. So it's a document, often very short, very simple, that says, Ron and wife are hereby transferring ownership of their membership interest in Clark Family LLC and RC LLC to the Ron and so Clark Irrevocable Trust. And then Ron and wife sign that as the transferor of their membership interest in the LLCs. Probably Ron and wife also sign accepting that transfer as the co-trustees of their irrevocable trust. And really that does it. And then, so that is what effects the transfer of ownership right there, done the same day you set up your trust. Now, I will say that check with your, most states have some annual filing or annual filing with your state, and maybe there's a question on that annual report to your state regarding your LLC. When you may need to update that to reflect who the actual owners of the LLC are, which would be your trust now. But really that transfer that you did on paper the same day that you form your trust is what transfers the ownership of your LLC. And then you're just maybe following it up with some documentation on an annual report with the state that if they even require that you show who the owner or who the members or who the managers of that LLC are. So hope that helps. Okay, so we talked about one of the common issues of a living trust is they don't get funded. And you might say, well, why is that a problem? Why is it so, isn't the creation of the trust sufficient to avoid probate? No, it's not. Because let's take an individual that has a house and he has 1,000 shares of ABC Inc. stock, and he dies and he has a trust, but his house and his stock are still in his name when he dies. Then, since assets are in his name when he dies, the house and the stock, the title of those assets is frozen. Nobody can do anything. And we will have to, or that individual's survivors will be required to hire lawyers, go through the probate process to get those assets transferred out of the deceased's name and into the heirs' names or into the trust names, depending upon whether he had a pour over will. We'll talk about that in a minute. So it's very important that when that individual set up his trust, he also retitled, it's another word for funded, he retitled his home, and we'll talk about how he would have done that, and he retitled his stock in ABC Inc. into the trust name, so it was already in his trust when he died. It wasn't in his name when he died. Probate governs assets that are in your name when you die. Probate doesn't govern assets that are in a trust, that are titled in the name of your trust when you die. The successor trustee that you name in your trust will have the really instant ability and authority to transact trust assets. And by transact, I mean sell if appropriate, but make sure the assets get distributed in accordance with the terms of your trust instrument. Typically, to the principal beneficiaries of your trust, which, so there we go. Okay. So I will also mention that in the example, let's say Fred and Wilma set up that trust. They had the home, they had the 1,000 shares of stock. If they did set up a trust and for some reason they didn't fund it, and we'll get into what some of those reasons might be in a minute, they likely also created, in addition to their trust, they created what's called a pour over will. And I've done videos, at least 2 or 3, on pour over wills that you can review. But that will generally says, Fred's will might say something to the effect of, if I die owning any assets in my name, I leave them to my trust. And so if there's assets in Fred's name when he died, yes, there still is required a probate, but the probate will send the assets directly from Fred's name to Fred's trust, and then that trustee can then disperse trust assets to the beneficiaries in accordance with the trust. You just got to do that extra step of going through the probate to get it from Fred's name to his trust. So be aware. It's typical for people to, when they set up a trust, to also sign their pour over will. All right. So what I want to do now is I want to go through how different types of assets get retitled or get transferred into a trust. And again, what we're trying to do is arrange things so that no probate is necessary when you die. In Louisiana, we call it a succession. But as you'll discover towards the end of this YouTube live presentation, sometimes, not all the time, but sometimes probate is unavoidable for reasons that I'll get to in a minute. Or in a few minutes, actually. So we'll get to that. All right. So first thing I'm going to talk about is the real estate. So let's talk about Fred and Wilma have a home. They set up their trust. They work with the lawyer to make sure the trust is customized to Fred and Wilma's specifications, if that's what you want to call it. And who knows what Fred and Wilma's family circumstances are. Maybe they have 3 kids and just want everything to be for the 3 kids after Fred and Wilma die. Maybe one of their children can't handle money, so their trust says, well, when Fred and Wilma die, that child's share will remain in trust, and it will be doled out over that child's life expectancy over the next 20 years, whatever the case may be. So, or maybe Fred and Wilma want to exclude a child, or maybe Fred and Wilma say we want $50,000 to be for each of our grandchildren, with everything else to our 3 children equally. So that's up to Fred and Wilma. Those are personal decisions, and their attorney, if their attorney does the job right, the attorney will guide them through those decisions in a way that Fred and Wilma feel like they've nailed it and it's perfect. So now it becomes uncovered that Fred and Wilma own a home. So when Fred and Wilma sign their trust, they also sign a transfer. We, Fred and Wilma, transfer our home from our names to the Fred and Wilma Living Trust, dated June 22nd, 2020. And so that transfer gets recorded often in the land records where the property is located. Again, some state issues could be addressed here. And then an extract or certificate of the trust also gets recorded in the land records to show who the trustee of that trust is. So if Fred and Wilma ever want to sell their home, which they very likely may, it'll be real clear in the land records who has the authorization to sell and transact trust property, Fred and Wilma. And maybe when Fred dies, Wilma's the trustee, so then Wilma would have that authority to do that. So that's how the transfer of real estate goes. Here in my state of Louisiana, when that transfer of the home takes place, it's often done with the settlors reserving what's called the usufruct of their home. That keeps their homestead exemption. But that's a Louisiana specific issue. But I know some of the people who listen in on these YouTube live presentations are from Louisiana as well. They should be, because that's where I am. And then also, if Fred and Wilma owned any other real estate, sometimes that gets missed. They're like, I forgot to tell you, Wilma owns this little piece of land with her 2 siblings that they inherited from their mother. And so it's real important that that also get funded into the trust. So then Wilma would sign the paperwork. I own this 1/3 undivided interest in this piece of property. I'm transferring it to the Fred and Wilma Trust. If it was the separate property of Wilma, it depending upon the trust terms, but typically it retains its separate property status when it moves into the trust. Okay, good. Thanks for the comment, Ron. And so that's the whole real estate thing. I will mention that many people own real estate, particularly rental real estate, inside of a limited liability company. And so we'll get to the transfer of LLCs and business interests in a minute, but some people, it's just may own 3 LLCs, and each LLC owns a rental property, and they want to get us all of these legal descriptions of all of these different properties that are in LLC so they can put all that in their trust. But in reality, if that property is owned by an LLC, They only need to transfer their LLC to the trust, and we don't need all of those underlying legal descriptions. We don't need to transfer the property to the trust. Transferring an LLC, which owns property, to the trust is sufficient. All right, so that's the whole kind of real estate piece. The next piece that I'll get into is the bank account piece. So there's a gentleman coming into my office today, and he is establishing his trust. And he's going to leave my office, and then he's going to go to his bank, and he wants to retitle his bank accounts, of which he has a checking account and a savings account and a CD. He's going to retitle those bank accounts. He's already talked to his bankers and all that. He's very organized. He's got everything lined up. But he wants that successor trustee to be able to immediately access those accounts upon his death without having to go through all the court stuff. And he doesn't want to give that successor trustee authorized signature authority right now because he wants to have 100% control right now. And some people are like that, and there's no problem with that. But so the transfer of bank accounts, this is where it gets tricky. The lawyer typically can't transfer your bank accounts to your trust. The lawyer can't have you sign something in the lawyer's office that transfers the title of your bank accounts to your trust. The settlor, the person who set up the trust, actually typically physically has to go to their bank to get their accounts titled in the name of their trust. The bank is going to want to verify the name of the trust, the date of the trust. They may even want to see the signature page of the trust to validate that the trust actually exists. So this is a piece. Sometimes people leave the lawyer's office with their documentation, with their binder, with their envelopes, and they go home, they put it on the shelf, they feel like they're done, but they're not, because they die, there's still accounts in their name, and those accounts are frozen, and we've got to go through the probate to get them transferred into the trust using the pour over will. So real important on bank accounts to ensure that in some way, and we talked about this yesterday for about a half an hour on yesterday's live stream, so you can go back and check that out, how to deal with the bank accounts. Next, I'm going to go through the kind of the securities or brokerage accounts. So I mentioned earlier, individual owned 1,000 shares of ABC Inc. stock. Most people who own stock, they own it inside of brokerage accounts, but many people also own stock through the transfer agent, like ComputerShare, for example. So again, takes some effort once you sign your trust to either get in touch with your brokerage firm, your broker, your financial advisor who oversees all of that for you. They're likely to be very familiar with retitling accounts into the name of a trust. So you'll have to initiate at least that conversation to let the financial advisor do what they need to do to get your brokerage accounts titled in the name of your trust. Or if you have stock through a transfer agent, you'll have to get in touch with that transfer agent and follow their procedure for retitling your shares of stock into your trust. So it's some effort now. Yes, it will save a lot of time, expense, grief on the part of your heirs and survivors in the future, but it is a critical component to transferring that stock or those brokerage accounts into your trust. The next thing, asset kind of class I'm going to refer to is annuities. A lot of confusion there. Many people own, I'll call them non-qualified annuities as opposed to qualified annuities, which are in your IRA. Many people will, at their bank, the bank annuity person, pull them to the side and say, hey, you got $100,000 in a CD here. Why don't you buy an annuity? Blah, 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 blah. And they'll do it. And so if the objective of setting up a trust is to avoid probate, it may not be necessary to transfer those non-qualified annuities to your trust because non-qualified annuities are just like IRAs and beneficiary and life insurance. They have beneficiaries. So if you're content just naming your spouse as your primary beneficiary if you're married, your adult children as your contingent beneficiaries or your primary beneficiaries if you're not married, then the ownership of your non-qualified annuities does not have to be retitled into the name of your trust because they avoid probate anyway. They have a beneficiary designated. Now, sometimes people need to designate their trust as the beneficiary of their annuities or their non-qualified annuities, because if that trust is very specific as to how one or more children are to receive the trust assets, for example, you have 3 children after you die to get monthly payments over the next 20 years, then you likely need to name your trust as the beneficiary of your non-qualified annuity. So those annuity proceeds would go into your trust, and then the trustee can dole them out over 20 years. Whereas if you just name your children as the beneficiaries of the annuity, they'll get that money in a lump sum, and you may not be accomplishing what you're hoping to accomplish. Okay, is there a downside to title? No, I mean, the short answer, no, there's no downside. We're going to get to vehicles here in a minute, or maybe we weren't, but I don't see it on my list. So no, it's not a downside at all. Now, here in my state, our Office of Motor Vehicles has created a simple procedure, if you follow it, to transfer title of vehicles that are in your name when you die. For example, if husband has a vehicle in his name and in his will he says, I leave any vehicles I own to my wife, then when he dies, the wife can produce a photocopy of his will and his death certificate, and they'll move those vehicles into the wife's name. The children have to sign off on it, but as long as everybody's cooperative, no court orders, no probate orders are necessary. But absent that, there is no downside to titling your vehicles, your cars, in the name of your trust. It will make it easier for your successor trustee to handle them if you pass away. And I would also suggest I've never seen a problem with automobile insurance, but just to be safe, it's recommended that you notify your auto insurer that your vehicles are in your trust, and they can list your trust perhaps as an additional insured. It doesn't cause your rates to increase or change or anything like that. So just be aware that that's out there. Hope that answers your question. June asked, if all your assets are put into your trust, what money can you use to live off of? What if I need money to travel or home repairs? June, it all depends on, June, what type of trust it is. If it's the typical revocable living trust, the June Revocable Living Trust with June as trustee, that trust typically provides that June can do anything with the trust assets while she is alive. She can buy, she can sell, she can spend. So if it's that kind of typical, when I die, I want probate avoided and I want the trustee to be able to immediately disperse things to my heirs outside of lawyer and court involvement, then you can do whatever you want to do with the trust assets if you need money to travel or home repairs or anything whatsoever. Now, there are other types of trusts, June, that you need to get some benefit from it. And because you or your family need to get some benefit from it, your access to those assets must be restricted. So, for example, the putting assets in trust for one's children to get it out of your estate to avoid the 40% estate tax. Maybe even also the get assets out of your estate so they're not yours anymore for nursing home purposes. Well, those types of trusts, you often, if not always, are required to restrict your access to those trusts, because if you have unfettered access to those trust assets, then those trust assets will be part of your estate for estate tax purposes, will be considered a countable resource of yours for nursing home purposes. So it depends, June, on what type of trust it is, and I hope that helps. And hopefully you are able to do a lot of traveling in our crazy world, and you may even have some time to do some home repairs because we're in a crazy world. Okay, so that's that. Going back to the annuities. So bottom line there, annuities often are not transferred to a trust, especially if it's the avoid probate trust, because annuities by their nature avoid probate anyway. You have beneficiaries named. However, two exceptions to that, you may need to name your living trust as the beneficiary of your annuities if your living trust specifies some type of restricted distribution to your beneficiaries, or if the trust that you set up is one to get assets out of your name for nursing home purposes. It may be appropriate then to transfer ownership of that annuity out of your name, because for nursing home purposes, it's all about what you own at the time that you go into a nursing home and apply for Medicaid. Okay, good one there. Business interests, we talked about that earlier. Many people own business interests. Not so much in what I'm talking to right now is the publicly traded stock. By business interests, I mean interests in LLCs, limited liability companies, interests in corporations such as subchapter S corporations that are privately owned. Some people own interests still in partnerships that are privately owned. And so those all, if you own an LLC and you leave it in your name and you pass away, then your survivors are not going to be able to transact that LLC, because as the owner, it needs to be transferred out of your name, go through a probate proceeding. That's why we want your LLC and your business interest to be in your trust, to make it easy for the trustee to transact all of that, either while you're alive or when you pass away. Okay, life insurance. Life insurance is a little bit like the annuities. Life insurance, by its nature, as long as you've designated beneficiaries, it avoids probate. So many people, especially married couples with kids, they name their spouse as their primary beneficiary. They name their adult children as the contingent beneficiaries. That works out just fine. However, if you have minor kids, if you have adult kids who the distribution to them needs to be controlled, then you may need to name your trust as the beneficiary so that it's not paid out to them in a lump sum. Same thing with the whole Medicaid trust type situation. I've talked about that in other videos. If you own life insurance and it's the type of permanent life insurance that has cash value, that cash value is considered a accountable resource of yours. If you go into a nursing home and you've got to deplete that cash value, which makes the life insurance go poof. And so many people who own life insurance with cash value, not term insurance, but life insurance with cash value, they often transfer the ownership of that life insurance to their trust to get that cash value out of their name for both the avoid probate and the nursing home stuff. Okay, now we've gone through the typical classes of assets. Non-titled personal effects, some people on paper transfer those to their trust, but since they're non-titled, the sofa, the china set, the jewelry, the rifle, the gun, the engagement ring, those things aren't titled. And usually what happens is, when parents die, the children just take physical possession of that, and everybody kind of goes their own way. All right, so now I'm going to go over the not much talked about scenario where even if you do everything right, there still might need to be a probate. Because sometimes when people die and they've dotted their I's and they've dotted their I's and they've crossed their T's, and they've worked hard to make sure that all of those assets that need to be funded in their trust are in their trust, they die, and then an estate asset pops up. We see this a lot sometimes when someone lives in an assisted living facility, or they live in a retirement community, or they live in a nursing home, and they die, and they prepaid the June rent $6,000, and then they die on June 4th. And now they're entitled to a refund of, $5,500 or whatever it is. Well, it's likely that assisted living facility, the retirement community, the nursing home, it's likely that they're going to make a check payable, and let's say the guy's name was Bill. They're going to make a check payable to estate of Bill. And the bank won't allow a check payable to estate of Bill to be deposited into Bill's personal checking account or his trust checking account. So now all the trust assets, they'll all avoid probate. That distribution should be easy by the successor trustee, but then there may need to be a probate proceeding initiated so that check payable to the estate of Bill can be transacted. Maybe the executor listed in Bill's pour over will, which they didn't think they were ever going to have to use Bill's pour over will because those wills are used only when a probate is required. But here there's a check payable to estate of Bill, either from the retirement community or maybe from the IRS, some type of income tax refund. And the executor listed in Bill's pour over will have to go through a process to get confirmed, open up a bank account in the name of estate of Bill so that those checks payable to estate of Bill can be deposited into the estate account for ultimate, transfer to the trust for disposition. So we see that sometimes. I'll also say that I think that the overused statement that an unfunded living trust is not worth the paper it's written on isn't entirely accurate, because let's say and he creates his revocable living trust and he either doesn't transfer any assets to his trust or he just transfers one or two assets to his trust. So he dies and he's got all these assets in his name, but he's got his trust, he's got his pour over will, and let's say Linda is the executor named in Bill's pour over will. She's also likely to be the successor trustee of Bill's trust, and she's likely also to be one of the 5 beneficiaries of Bill's trust. So when Bill dies with his unfunded or underfunded living trust, yes, a probate is necessary, but the beauty, and beauty's maybe a strong word, is the good news is, especially if one or more of those 5 heirs, beneficiaries, whatever you want to call them, the relationships are not perfect and there's the potential for contention, then when Bill died with his unfunded or underfunded living trust, but with his pour over will with Linda as the executor, and the pour over will directs that if he does have anything in his name, he leaves it to his trust. There's only one participant to Bill's probate. It's Linda. She's the executor. So she's involved as a participant as the executor of Bill's probate. And she really is the only heir involved in Bill's probate, because everything that is in Bill's name when Bill dies goes to Linda in her capacity as the successor trustee of the Bill trust. So Linda by herself can go through all of that probate rigmarole without the other 4 people. And when you only have one participant in a probate, there's not going to be a contested probate typically, because it's just one participant. The problem is when you have multiple participants, nobody trusts each other, nobody signs all the different layers of paperwork. But when you have one, it's simpler, typically. So Linda completes the probate, gets those assets transferred from Bill's name into the Bill trust. Now she can work with the other 4 beneficiaries of Bill's trust and then just start making disbursements and distributions to them, selling what she needs to sell. And she can do all of that without all of the court and attorney involvement that would be required if 5 of them went through a probate process together. So I hope that helps you really kind of understand that really the unfunded living trust is not this thing where it's not worth the paper it's written on. It can make the still necessary probate easier because there's only one participant to it. Okay, so with that in mind, there's your summary. And so here, if you have some questions or jokes, live chat, way to go. We got another minute or so. We've got good participation today. I'm pleased. And I want all of you really to jump on. We got 3 more of these to go. This was number 17 out of 20. It's every day. I post it on the community tab on my YouTube channel called Rabelais Estate Planning LLC. Every day I post the next day's link so you can jump on there and get to it. Make sure you also hit the like button and subscribe. That helps the YouTube, or tells the YouTube algorithms to show my videos to more people. If you live in Louisiana, want to have a conversation, go to my website, RabelaisEstatePlanning.com. Click on the link that takes you to my calendar. Schedule a call. I'll call you at the appropriate time. We'll have a conversation and go from there. Really appreciate all of the good jokes. Excellent questions. Alex, you're welcome. And glad you found it educational. I know we've educated more than 4,000 people in our 16, now 17 YouTube live presentations. I'm excited about the participation that we've had. You've forced me to really up my game, to do my research, to learn to communicate what can be complicated issues in relatively easy to understand terms. So this is a win-win-win for everybody involved. Feel free to share these with others, and so we can get more participation. We'll see you tomorrow. Y'all have a good day. And Hoop, thanks for your comment as well. Happy Father's Day to you. See ya.